We are now on the record in the case of City of Wichita versus Carl Peterjohn and Celeste Rousset, individually and as representatives of Save Century 2 Committee. Counsel are present in the courtroom as previously announced for the plaintiff, Sharon Dickrath, and for the defendants, Chris Snow and Wendell Snow. The defendants are also in the courtroom, Carl Peterjohn and Celeste Rousset. Counsel, when we recessed last evening, I told you we'd try to start at 10. I apologize. The 9:30 thing I had took just a little longer than to resolve getting a journal entry completed for that case. We're now beginning, but I wanted to go back to, before we do closing arguments, to make sure that we give you the opportunity to make sure all of your exhibits have been admitted.
I can approach. We talked about changing out defendant's exhibit number 10 for the entire code of the Historical Preservation Board. They've got the copy, and I think the court reporter has revised.
Do you have any objection to that, Mr.
Your Honor, I just received it. I'm not looking, but my understanding is Mr. Graff is what you described.
Okay, thank you.
And then you had asked for a copy of the city's exhibit list that had been admitted in mail. I'm pretty sure she has them all.
Okay, thank you.
She has them.
And for the plaintiffs, I have, as admitted, the minutes of the August 4th City Council meeting, the portion that was attached to the affidavit. The 4-page portion that was attached to the affidavit of Karen Sublette. The city news release that was dated July 29, 2020, that was testified to by Ms. Lovely. The city petition for historical city-owned buildings was their Exhibit C, which is just a copy of the defendant's petition, a blank copy without any signatures on it. A copy, Exhibit D, was a letter, a copy of the letter from the county councilor dated January 10th, in which he indicated that the form of the question on the petition complies with the requirements of statute. And the affidavit of Ben Nelson, which is briefly is long, and Mr. Nelson testified yesterday. Then the copy of the Wichita, Kansas Code of Ordinances, beginning with 2.12.016. Excuse me, beginning with 2.12.1015 regarding the Historic Preservation Board, continuing through 2.12.1025, has been presented to the court, is to be substituted for the defendant's Exhibit 10, which only had the first, I think, 2 sections of that ordinance. And the defendant's Exhibits 1 through 11 have been admitted.
Don't we did Exhibit 7?
Oh, you're right. Yeah. 1 through 11, except except for 7. One other I need to.
And portions of.
And portions of number 5 were not admitted. So the exhibit 5 was admitted except for now I don't know where I put the copy that I had marked, which ones were not admitted. What? Can you put it in the record?
This is the record, but I believe these at this point in time, it is paragraph 7, section 7, and section 16 through 21.
You disagree, Ms. Ditka?
No, I don't, sir.
And now that you've said that, that's what I recall. Thank you, Mr. Smith. We are then here for oral argument or closing argument on this trial. And I'll turn first to you, Mr. Kraft, because we're here on your petition.
May it please the court, counsel. KSA 12-3013 establishes a procedure where voters of a municipality may propose legislation for the city council. That statute, along with KSA 25-3601, sets forth requirements to have a ballot petition. There are several things that are important to note about this process. First is that that right is only given to municipal voters. There is not a similar process for county or state legislation to be proposed. If a valid petition is presented to the city, the statutes are very clear as to what the city's responsibilities are. That they have to pass the ordinance as written without any alteration or place it on a ballot within 20 days. If that ballot is then voted affirmatively, that legislation is in effect for 10 years or until it has been voted by the citizens to either repeal or to amend that particular legislation.
In other words, if it was created by the citizens have to vote on it for repeal.
Within a 10-year period.
Right.
The petition, and we've talked a lot over the last day regarding the language of the petition, and it is in the record in city's exhibit number C. I think it is important to note the language of the petition being that it reads, no prominent city-owned buildings of historical importance or architectural significance, regardless of historic register status, including Century 2 and the adjoining former public library, shall be demolished, replaced, or otherwise adversely affected without a public vote of approval by the qualified voters of the city of Wichita. And then there is a second section. For my closings, I would like to cover 3 particular areas. I'm not going to cover everything that was in the city's memorandum. The statutory deficiencies in the petition itself, the administrative nature of the ordinance, which is precluded from this process by KSA 12-3013E, and the invalidity of the proposed ordinance. There's been much discussion in both the city's brief and the defendant's brief as to what the standard is, whether it is a substantial compliance or a strict compliance. It would be the city's position that based on the AG opinions and the language in the Schmidt versus City of Wichita case, that the standard is a strict compliance. In Schmidt, the court stated that KSA 12-3013 plainly states what is expected of electors who wish to submit an ordinance to the city's governing body to eventually become law. So our liberal construction of KSA 12-3013 is not required. The holding in Schmidt was shall mean shall.
I just want to note I did read the Schmidt decision, and I recall in that decision that the city, as I understand it, actually argued in that case that there was substantial compliance and that was good enough.
I did.
And that's probably hard for the public to consider, or I know that as an attorney representing different clients in court, I've used opposing arguments in domestic cases at times based on the facts or based on which argument would be beneficial to my client. I understand, and quite frankly, attorneys are skilled to learn how to argue either side of a question. That's one of the things that is taught in law school, and how to do so effectively with the best law and best evidence that supports that argument. It strikes me that that's an unusual thing to argue with regard to the same piece of law, but I understand the circumstance, and I don't have any fault for the city doing that.
That the position hasn't changed necessarily. It's that the Schmidt case answered that question. It was asserted in Schmidt by the city that substantial compliance was enough, and that the copy of the ordinance had made it to the city council and had made it to the city attorney, and therefore that was compliance with the requirement that it be filed with the city clerk. Even if the court applies a substantially compliant standard, the petition doesn't meet it either. Defendants in their brief want to say that they minimally substantially complied with the statutes. I don't believe that's either one of the standards that have been expressed by the courts or the Attorney General. As outlined in the city's memorandum on pages 5 and 6, there are a number of fatal flaws to this particular petition. The first is that
let me stop you. I want to also just make a point that I did read in the defendant's response to your arguments on this, and I'm not finding it right now as to where this was stated, but there was a statement that was made by the Supreme Court that implied they didn't even decide the question of whether it was substantial or specific compliance that was necessary. And in fact, close to the end of the case on page 293, and I believe, no, that's from the Pacific Reporter, I think. It's on page 667 of the decision in the Kansas report. The Supreme Court said the city has generally argued that substantial, not absolute compliance with KSA 1230-13 is sufficient, assuming without deciding this is the correct standard. In addition to what we have already stated, we further observe this case is readily distinguishable from others in the initiative and referendum area in which the standard has been applied to aid the party asserting. So that statement kind of, to me, gave me the impression that the defendants were right. They really didn't say which standard. In that case, the Schmidt case, whether it was a specific or a substantial compliance standard, they're saying it didn't meet either.
That's correct. The court went on, though, to say that based on the express language of the statute, that it should not be given a liberal construction. And generally, shall means shall. Shall doesn't mean may from a pure technical statutory construction. Even if the court applies a substantial compliance regarding the petition itself, it doesn't meet that standard. There are a number of fatal issues with this petition. The statutes are clear that the petition has to do at least two things. One is ask the governing body to do something, i.e. pass the ordinance or call for an election. And that is specifically stated in KSA 123013. Both of those things are missing from this petition. This petition doesn't ask the city to do anything. This petition uses phrases such as petition or ordaining, but those are not explicit words set forth in the state statute that says you have to ask us to have an election. The defendant admitted during my cross-examination that the word election does not even appear in this petition. Other issues are outlined on page 5 of the city's memorandum. City would admit that those, for the most part, are pretty technical. Verbiage should be, shall the following be adopted? The purpose of that is so that it's clear to the election commissioner what the verbiage on the ballot should be. This petition does not contain that verbiage. City would assert and has asserted in its brief that there are a number of issues, and I think I said topics in my brief, and defense counsel was correct, it's not topics, it's issues. In that you have historical buildings, you have architectural buildings. Ben Nelson testified as to the number of buildings. I understand that defendant's argument to that is, well, but we're only really talking about buildings on the historical registry. That's not what this petition says, which is another issue when I get to the end of this argument regarding the vagueness and overall validity of this particular ordinance.
Let me go back to something you just said I want to address, if I can recall it. We're moving on fairly quickly, which I compliment. Where is the section that in the statute which says, and I've read it, that says you have to ask them to approve it or put it for election? Is that in 253601?
No, it's 123013.
Okay.
The very last sentence of subsection A. If the petition and the proposed ordinance is signed by the required number, the governing body shall, A, pass such ordinance without alteration within 20 days of the first certificate, which is the verification of the signatures by the election commissioner in this case, or if not passed within 20 days, call for a special election.
But your argument is not that the city has to do that. It's your argument is that the city, the petition has to ask the city to do that. One of those two things.
Yes.
Right?
Yes.
But the shall in that phrase refers to the governing body, not the petitioner.
Yes, but in the prior part of subsection A, the very last sentence of right before the signatures on the petition,
it ends with shall contain a request that the governing body pass the ordinance or submit the same to a vote of the electors.
Right.
I understand the defendant's argument to that is that, well, that's essentially what the title of the document said. It implies that is what the other phrasing, shall the ordinance become effective and be it ordained that the governing body of the city of Wichita, Kansas, then stating the essential part of the ordinance. And they're claiming that that does do that. And I think one of the things that it hits me is that I don't think the city had any question or lack of understanding that that's what this presentation of the petition did, because they acted at, just as you described the governing body has to act. They either have to pass it without alteration, or if not passed, forthwith call a special election, or I'd say there's a third option, which is file a lawsuit within 20 days. So the petition doesn't pass just forth, or is it, it doesn't just become law, correct?
I would agree that those would be the city's options.
Okay.
I don't agree that that language isn't required by the statute. I understand that the city acted on the petition as it would with any other petition. However, the court's job is to construe the statutes. This is clearly an issue of statutory construction. If you apply the general long-term decisions on statutory construction, you don't read something and it's not there. The words are given their express in ordinary meanings, and to have an ordinance, or I'm sorry, to have a statute that states that the petition shall do two things, it would be my position that is what the statute meant. And certainly it's up to the court to determine whether or not the petition complies with the requirements of the statute. The last procedural issue is that the proposed ordinance does not specify the number or title of the ordinance. Generally, I don't know that that would be a big deal. However, in this case, I think it really is. The defendant spent a lot of time yesterday talking about areas or ways to define the term so that it wouldn't be unconstitutionally vague. And they looked for the Historical Preservation Board and the Historical Preservation Ordinances, which the court has been provided a copy of. The problem with that is that this petition doesn't reference that at all. The petition doesn't say this should be codified in section 2 with those existing ordinances. It doesn't utilize the same terms that have been used in section 2 of the city ordinances. And it references a number of terms that candidly are not in the city's Historical Preservation Board ordinances. So in this particular case, while that seems minor, if it's the defendant's position that those should somehow be engrafted onto the ordinance, which I will cover later, I don't think is appropriate, there is no way that a person reading the petition alone would assume that the intent was to have an existing city ordinance provide those definitions.
Let me address, though, one of the things that you just raised. This argument that you're making now, or asserting now, is what's number 4 on page 5 of your memo. And I'll just read it. It says 4. Fails to specify the number and title of the proposed ordinance, contrary to KSA 25-3602A. I looked at 25-3602A. I think you misreferenced the statute, because that language about a number and a name is not in that section. Where it is in 25-3601C, the prior statute. And in the last statement right before, where it says, shall the following, that you've got to have, shall the following ordinance or resolution become effective, it says, as you would indicate, such petition states the title, number, and exact language of the ordinance or resolution, and the title of such petition says, shall the following ordinance or resolution become effective. The problem for me is that statute, subsection, if you go back to the beginning, the first sentence says, the form of any question in a petition requesting an election on or protesting an ordinance or resolution. So it's that hits me as it is to protest an ordinance or resolution. It's a protesting petition. And then a protest petition, they would be designating the ordinance that they disagree with, they don't want to become effective, which would have been passed by the city, and it would have a title and a number. Generally on where a petition is filed to adopt an ordinance, and that language is in a different statute, and the language, there is even different language for a petition in Article 12, Section 5 of the Kansas Constitution, which to me leaves us a confusing situation for anybody drafting a petition to figure out which one they're supposed to use.
And I would just like to address that particular topic for the record, and I understand that is the defendant's argument. However, when you read C in its entirety, the form of any question in a petition requesting an election on or protesting an ordinance or resolution. It's my reading that it's an or, that applies to both a protest as well as this process. And again, these are statutory interpretations for the court to determine. But I do think in this particular petition that is an important fact based on the defendant's testimony, that it appears it was their intent to read into the ordinance the historical preservation code sections.
I think one of the things that challenges that statutorily is that KSA 25-620, which is the one that uses the language, shall the following be adopted, says at the beginning, except for propositions to amend the Constitution, when a proposition or question is to be submitted to the voters of the state or any part thereof, a separate ballot, there's no reference to a protest petition. It seems to, this section seems to deal with petitions asking for the creation of an ordinance. And there, the words are, shall the following be adopted. But if subsection C applies to 253602 applies to those petitions as well to adopt an ordinance, it says the title of the petition shall state, shall the following ordinance or resolution become effective? And you've critiqued the plaintiffs or the defendants for using the words, shall the following ordinance become effective, because they didn't use shall the following be adopted. But if it was a petition to propose or petition requesting an election, then shall the following ordinance become effective seems to me to be appropriate.
I would agree with that, but for subsection D, as in dog in 253601, that specifically says if there is another statute that has more specific requirements than 253601, you look to that statute. And in this particular case, that statute is 123013.
Okay, and the way that seems to me, that is stating a common interpretation of law, which is if you've got two statutes, one very general and broad in its terms, another very delegated to a certain subject, then the more specific statute controls for that subject. if there's a difference in those two laws. That's a fairly basic interpretive.
Yes, I would agree with that.
And I don't see these two as being that different. That one is general and one is so much more specific. They're both dealing with petitions.
But 123013 is more specific because it only deals with cities and it only deals with the initiative process, which is only granted to cities.
I understand that argument.
So that would be my argument. The next issue is whether or not the ordinance is an administrative ordinance, which is precluded from this process by KSA 123013E as an element. The courts have established essentially 4 criteria to determine whether or not a proposed ordinance is administrative or legislative. This process is only allowed for ordinances that are more legislative in nature. The cases do not weight one of these criteria more than the other. The cases do not indicate that a majority of these elements need to be met. They discuss them and then determine whether or not the proposed ordinance is more administrative or more legislative. The first topic or issue is, does the proposed ordinance create a new law? And until yesterday, I would have agreed that it did create a new law. However, based on the testimony that defendants presented, this proposed ordinance is really not a new law. This proposed ordinance seeks to execute an existing law, which was discussed in McAllister versus City of Fairway, which is on page 6 of the city's memorandum. If their arguments are correct, that they intended that this ordinance would be in, or would be a companion ordinance with existing ordinances, it really only implements the policies already set forth in the city's code, which are contained in sections 2.12.1015, and the actual city policy is set forth in 2.12.107.
I understand your argument is, well, but that can't be the way to interpret this ordinance or this proposed ordinance because they didn't reference that to define it.
That's true. But in their petition, there are several instances where they want their cake and want to eat it too. The city doesn't have any special knowledge required in this ordinance, and then it says, well, it's not vague because the city has that specialized knowledge. Those are contradictory arguments. So it really depends upon how the court interprets the petition and the existing city ordinances.
There is the McAllister versus Fairway case does list those 4 factors and it sets them out. I believe it was the case. I've read so much I can't remember which case and what and which page it was on.
On page 6 of my brief is the McAllister case, and they were restated in the Emming case that we talked about earlier.
Okay, and then the Emming case has a list, is that right?
Yes.
Of 1, 2, 3, and 4?
Yes.
Okay. The question I want to ask you is, I remember reading somewhere in one of these cases that these, essentially, as I read it, that it wasn't necessarily a list of 4, and if you check more than 2 or more, if you check 2 of each, it could go either way. If you check more than 2 of one, the decision has to go one way or the other, either legislative or administrative. But I believe there was a case that kind of said that, in some sense, that if the ordinance is predominantly administrative by one of those factors, that can be enough. I can't remember which case that was.
I think that's generally stated in a number of cases, but you are correct. The Supreme Court has given these 4 criteria and has not said, gee, if it needs to be 1, or one's enough. The McAllister case, maybe during his closing, I can look it up. The McAllister case, I believe, did hinge on primarily being administrative. That was the case where the legislature, where the city wanted to
Move its city hall
move its city
facility.
hall, and the citizens didn't want it built in a particular area. Of those criteria, the most dominant one was the administrative nature of that decision, that the city had increased knowledge of funding, where it should be built, zoning, planning, the taxpayers versus City of Wichita case, which dealt with the stormwater solution, or stormwater and sewer taxes and solutions. Again, most of the criteria that were met were, in fact, the administrative part, the city's knowledge and expertise in that particular area. And given all of these factors, clearly the one that is the most clearly met in this case is whether it is a topic or decision that requires specialized training and experience by the city government.
Which is, I think, the third
It is.
in the list later.
And I'm not going to regurgitate Ben Nelson's testimony. Not all of it I understood. But he did give a good background as to the types of things that the city would evaluate in looking at a property. The useful life of the property, different funding for property, the uses of the property, long-term use needs, as well as size needs of the property. Those are all areas that would require specialized knowledge by the city, which would allow the ordinance or cause the ordinance to be more administrative in nature. Along those lines as well, the defendants in their memorandum state that the city has specialized knowledge regarding the historical importance and architectural significance of buildings in general. Taking that literally, they admit that this particular ordinance would require, in order to be valid, that level of expertise in relation to historical buildings. So I think there's two bases that make this an administrative ordinance. One is the general knowledge and expertise that's needed by a government to regulate its own buildings. How long do we keep it? How do we pay for it? What should it be used for? What is the best use of that building? Those are all decisions that require cash-based law, budget issues, geo bonds. There are complex issues involved in those particular decisions. Additionally, because of the historical nature of this petition, and the terms are not being defined, you have to define them. And defendants have said it's not unconstitutionally vague because the city has this expertise. If it's required to have expertise to have information about historical buildings, that would tend to make this an administrative ordinance. The fourth.
So your second point then is
What?
of those.
Well, the second one was declares a public purpose and means to accomplish that purpose. There's not been an explicit public purpose set forth in this particular ordinance. It doesn't really.
No, I meant the second argument you were that made it administrative. Yeah.
Would be the historical preservation aspect. Defendants in their memorandum stated that the city council has specialized knowledge via experts at its disposal with respect to the proposed ordinance's allegedly unconstitutionally vague historical importance or architectural significance criteria. They outlined yesterday and outlined in their brief the processes that are set forth in the city's ordinances. The Historical Preservation Board does require members that have special interests, knowledge, or training in fields closely related to historical preservation. Architectural history, building trades, those are all areas of expertise that the city, in implementing this ordinance, would have to have. which would tend to make it an administrative ordinance.
Okay, thank you.
Regarding the last criteria, which is the subject matter has been delegated to the makers of the governing body. In the city's brief, I have listed a number of statutes that give the city's authority to own property, sell buildings, purchase public buildings. Those are all expressly granted to governing bodies. In addition, state statutes also delegate historical preservation issues to governing bodies. KSA 75-2724 allows the state to enter into agreements with cities and municipalities.
Say again, 75,
2724,
thank you.
and I have a copy of that.
2724?
Yes. And I can provide the court a copy of that
Okay.
ordinance. So I need to approach.
Yes, please.
It's in E1. The State Historic Preservation Officer may enter into an agreement authorizing a city to make recommendations or to perform any and all the responsibilities of the State Historic Preservation Officer. The city has in fact entered into that agreement, which is outlined in the city code that was produced to the court. That we are a certified local government, which is defined in section 2.12.1016 of the city code. Based on the four elements taken together, and I would agree with the court's interpretation of the cases, that one is not weighted more heavily than others. All three or four don't have to be met. But when you look at the overall structure of the proposed ordinance, it is an administrative ordinance. It deals with issues that have been delegated to the governing bodies. It deals with issues that require a level of fiscal affairs, financing, construction. All of those things would be specialized for a city government. The last basis for the city's motion to dismiss is simply that the proposed ordinance is not a valid ordinance. The proposed ordinance exceeds the city's lawful authority to pass an ordinance calling for a binding election. This issue was not addressed in the defendant's memorandum. The ordinance states that the city will call for a binding election or the approval of, without a public vote of approval, before a building of significant or historical architectural significance is demolished or otherwise adversely affected. Elections are clearly creatures of statute. The Kansas Constitution provides that elections shall be as determined by the legislature, exact language. And unless the legislature grants that authority to have the election, there's no basis to have an election. The most recent case that talks about that particular issue, and I'm going to massacre this thing, it's on page 12 of the city's brief. It's
Maharaj.
yes. Talked about that there was no constitutional right to a referendum. I understand that the referendum is different than the initiative. However, it is the same analysis that unless there's a statutory right to call for a binding election, the city can't ask for one. The city clearly acknowledges that based on its home rule authority, that the city can call for an advisory election and has called for an advisory election. I can't remember exactly what the topic was.
Well, based on what I heard from Ms. Rossette's testimony, it sounded to me like the city may have done that in 1969. They asked for an advisory, 1960s somewhere. They asked for an advisory election to see if the Century 2 building and the library should be built, if the citizens supported that.
My
And they didn't
understanding,
check to see.
my understanding of her testimony was that they had a vote on the bonds for the buildings to be built. And there is a specific statutory means for the electorate to approve bonds for certain types of financing. So that was how I understood her testimony, but I may have misunderstood.
Well, I was alive in Wichita during that time, but I wasn't paying any attention to elections at that age. But it appears to me from the statutes that deal with the issue of an initiative or a voter initiative petition that the state has delegated to the city the ability to call binding elections if they receive a election or a petition that proposes a new ordinance, or if they receive a petition that protests an existing ordinance, or if they receive a petition that protests a charter ordinance. From this case, that's the ones I know about that allows the city to create a binding election. And you're saying there's another one for bonds?
Bonds. There are sales tax can be voted on and be a binding election. There are some bonding provisions that can be voted on in a binding election. And I don't have those sites with me right now. And I would agree with the court that 12/30/13 allows the city to call for a binding election on the proposition that's been presented. The petition essentially negates 20/30/13 by saying we're going to require you, city, to call a binding election for the next 10 years based on this petition without following the process that's outlined in 12/30/13. Because you're
Or
right.
253602.
Right.
No, 253601C.
Yes.
So,
But I'm sorry.
so in that sense, could it be said that the petition, going back to the prior point, is administrative as to something that is delegated to the legislature? Because the legislature has the authority to say who can call elections. And this ordinance seeks to say, well, we want our city to be able to call elections in this manner when there isn't authority in the statute, by statute, for a city to call this election. A statute written by the legislature. Do you understand that?
Yes, I do. And yes, I would agree with that. That also, frankly, fits into the number 4 criteria of the administrative ordinance, that it's a subject matter of statewide concern where the legislature has to get delegated decision-making to the governing body, meaning that in this particular case, that decision-making is limited by the constitutional provisions regarding elections. So yes, I would agree that this ordinance would be administrative in nature, and that it's asking the city to utilize authority that's been delegated to them from the legislature, but in a manner that's contrary to the state statute.
Yeah, and I've tried to work my mind through that and see, and it ends up being circular. It sounds circular all the time. but I find it potentially persuasive.
The last basis is that the language utilized in the proposed ordinance is unconstitutionally vague. There are a number of terms that are not defined. What is a building? What is prominent? The defendant yesterday testified to her definition. Having said prominent, there are certainly buildings on the historical registry that are owned or were owned by the city of Wichita that may or may not fall within that definition of prominent. The golf tee shelters at Sims Park, bathrooms at the Comfort Station, the bathhouse, those were all examples that were given by the defendants of property that is on the historical registry without a definition of prominent. We could be required to have a vote as to whether or not a bathhouse or a golf tee shelter could be torn down. The ordinance does not require or does not define what is historical or architectural significance. Again, that term is not a term that's used in the city's ordinances. It's a variation of that. There's no definition of adverse effect. The language is very broad. The last section of the proposed ordinance, which we haven't really talked about a lot, but talks about that the property shall be leased, sold, bartered, traded, conveyed, or assigned, and thereafter demolished, replaced, or otherwise adversely affected without a public vote. What would be adversely affected could be a number of things. So we lease Century 2 to Music Theater, and they remove all of the wooden floors and all of the wooden stage and replace it with fiberglass. Has that adversely affected the building? And those are all subjective terms that do not make this ordinance definitive enough to pass muster or an ordinance that the city would have to determine how to enforce and what elections would need to be called, what buildings would fall within those criteria. And based on that would be the city's position that the ordinance is unconstitutionally vague.
I want to ask you about that. Is that question even right for the court at this point in time? Because it seems to me that courts typically avoid questions of constitutionality if it can be decided on other issues. There is a requirement that I've also learned about because I violated, that if the court wants to take a statute and make it unconstitutional in the manner it's stated, a court makes that decision in some case. We have to, before I could make that decision, I learned, I have to inform the secretary or the attorney general. So the attorney general can file a brief in the case and enter the case to determine whether it is completely unconstitutional. If I just simply say it's unconstitutional in the application that's being used here, I don't have to inform the attorney general. So I'm concerned that if I go to that issue, maybe we've got to stop and we've got to contact the attorney general. The difference, I suppose, is that I'm not dealing with a statute that is already in existence. I'm dealing with a proposal. And to that extent, am I not just saying it's my impression that if this were passed, it would be unconstitutional? And to me, I'm not sure that's binding.
I think that issue is right because there's case law and attorney general opinions that talk about that a city can decline to put an ordinance on a ballot if it is unconstitutional. And the one that would come to mind is the attorney general's opinion where a ordinance was proposed regulating abortions within the city of Wichita. The Attorney General said because of the unconstitutionality of the issue, we can't regulate it or can't prohibit abortions, that the city was proper for not putting it on a ballot. So I do think that that is proper and is right, because the converse would be if you don't address that now, then it could be put on a petition, voted in. We would be back to the Schmidt issue. And in Schmidt, the city put it on the ballot, voters passed it. The Attorney General said, nope, not legal. We went and argued that it was legal, that the basis was legal, and we lost that at the Supreme Court. So much the same analysis would go into the court's reasoning here, that that is right. Regarding notifying the Attorney General, and I haven't looked at that particular statute, since this is a city ordinance, I don't know that we've ever notified the Attorney General if a city ordinance had been declared unconstitutional, as opposed to a state statute. And you may be, I haven't looked at that statute to see whether there is that distinction that's been made.
Well, I had a question that popped into my mind and then lost it. Is that the conclusion of your argument?
That is the conclusion based on the arguments submitted in the city's memorandum, as well as the oral arguments. We would ask that the city's petition for declaratory judgment be granted.
So as I hear you arguing here, you basically asked for it to be determined, the petition to be denied under 7 different reasons. And I think what I'm hearing you say is that if I find it should be denied for any one of those 7 reasons, it should be denied.
Yes.
Well, I'll address you initially as Christopher Snow. She just set a pretty high bar for the defendants in this case, because she's saying that there are 7 reasons that the ordinance is invalid, and for it to be determined valid, you have to win every one of them. And if she wins one, she wins. So
that is her argument.
tough deal. Your turn.
May it please the court. Based on the court's remarks with respect to it's obvious that the court has read the Schmidt decision and understands that they did not make a decision one way or another what was the standard. And I also thought the court's comments to counsel, that counsel at times have to argue opposite sides of an issue in different cases, is certainly germane. And I won't overly belabor this, but unless I misheard the city's council's comments earlier when we were arguing the motion to dismiss, she's actually argued for a substantial compliance standard to apply to the city's compliance with respect to their own code provision relative to the public agenda. So I guess this is perhaps not a legal argument, but more one of equity. What's good for the goose is good for the gander, Your Honor. What is fair for the city should be fair for the defendants as well. And other than that, on the substantial compliance argument, I think that we briefed and set forth our position there. Say, for one thing, I do want to emphasize that the defendants consider the fact that the Sedgwick County Councilor, they submitted the petition for review and an opinion as to the legal sufficiency of the petition as required by the statute to the Sedgwick County Councilor. He approved it under both 12.3.013 and 25.36.01 without qualification. And I just wanted to bring to the attention of the court that the Kansas Supreme Court's decision in State versus Jacobs, which we cite in our opposition memorandum, at least based on my read of the case, that the court held in that case that the claimed defects and irregularities in the petition and the alleged insufficiency of the same had been determined by the city clerk in that case. I'm not going to tell you exactly what statute applied then. And the court says that it bears the certificate of sufficiency by the city clerk under the statute requiring the city clerk to determine the same, which in the absence of fraud or misconduct is binding and conclusive. So I think in that case, at least based on my reading, the Supreme Court viewed, for lack of a better term, a clean bill of health on the form of the petition is significant, and I'm arguing by analogy that is both the purpose of the review by the county council requirement, and that is on the site for that statement.
Yeah, I missed that case. It's State by Malone versus Jacobs, so it's kind of, I don't know if it's titled as Malone versus Jacobs, but 135 can 513.
Yes, and the holding I was perhaps not very eloquently quoting is at page 517 of the Kansas Court.
1932 case.
It's old, but it's rather old, but I will note that it was cited by the Kansas Supreme Court in this decision.
I can try. I have kind of noted at times when counsel argue to me based on old decisions, and you don't come close to the record here because I've had a case, I think, where it was argued on the basis of a 1881 decision approximately, and quite frankly, it was still good law. So I understand the age doesn't necessarily say anything about the argument not being valid.
And I would just add that the Kansas Supreme Court Schmidt obviously felt we needed to distinguish that decision because it had applied a substantial. I will not belabor those points. I think we've addressed some of the statutes that we're relying on. I think, frankly, Your Honor has picked up on it, so I'm not going to verify that language of their terms, particularly 253601C, and we would urge that substantial compliance is appropriate as the others that we've satisfied. And so now I would like to turn to what I think is the city's primary argument, or at least one of them, and I would note that at least until this morning, that the city, and I think this is at page 7 of the memorandum, had conceded or argued that defendants' proposed ordinance created new law. And if I understood the city's council's arguments today, they no longer take that position. That they are claiming that the proposed ordinance would simply deal with the administrative procedures of the Wichita Historic Preservation Board. And she made some comments about the defendants, for lack of a better term, making inconsistent arguments. And I guess what I would say there is I'm a little confused if the city is now arguing that this is not a new law, but it's simply a law that already affects existing ordinances. It's unclear to me whether or not whether or not they still want to argue that the language of the proposed ordinance is unconstitutional. I would respectfully suggest.
I think what I understand from the city's argument on that point is that we are dealing with a petition drafted by voters and presented to the city council. And yesterday in testimony, Ms. Rousset gave testimony to say that the terms, some of the terms in the petition should be understood to come from the Historic Preservation Board definitions in the city code. And that by making that argument, it's contrary to what's in the ordinance, proposed ordinance itself specifically, because it doesn't give a reference to the Historic Preservation Board. It doesn't give a reference to the code. It doesn't give a reference to those definitions. It doesn't establish a definition for prominent or a number of other items. In fact, it says historic register status doesn't matter, which I was given a list by the defendant yesterday of, I think, 15 structures in the city of Wichita that are on the Wichita Historic Register, including Century 2. So what they have proposed here, if I read it with the petition, is it doesn't matter if Century 2 is on that historic, the Historic Preservation Board's list of 15 places, which it is now, wasn't when the petition was started in January. And that's by the yeoman's work of Ms. Rousset and maybe others with her.
Yes, John, the point that I was trying to make is if we were under the guidelines that the courts have articulated to determine whether or not the essential character of a proposed ordinance is either legislative or administrative. The first guideline that
is it's legislative.
Yeah, does it have the key attributes of permanency and generality? And at least prior to today, the city had taken the position that it did create a new law, or that it would, and that it was so general that it was overbroad and constitutionally vague. So the point I am simply making, I will address as best I can, the vagueness argument we get there is that if the city is now telling you this is not general, and they want the benefit of the contention that the definitions they contend are vague are sufficient to give an administrative characterization. Talking about that, and candidly, it's inconsistent with their argument to you that the terms are so unconstitutionally vague and overbroad, the petition should be dismissed. So that was the point I was perhaps not making in a clear enough fashion. But so turning to the text, and regardless of that point, the first guideline is whether or not
it's legislative.
Yeah, whether or not it's legislative, and whether or not it has the key attributes of permanency and generality in creating law. As we said in our brief, we would suggest it does. It clearly announces a standing rule of the government, and that's one of the things that the council court looks at. Also, the city of Topeka versus any case held that the subject matter of public improvements in general has been afforded a legislative distinction. Second, turning to the contention that it doesn't state a public purpose, that the Supreme Court in the council decision expressly said that it doesn't have to state explicitly a public purpose. If that can be inferred from the content of the proposed ordinance. I would, as a practical matter, I think that's respectively apt here. This is a citizen's petition. It's not a petition drafted by a governing body or legislature.
Although sometimes they don't necessarily do that great a job either.
I will proceed to the fourth guideline if that is an
Okay. So you've addressed the first two and the fourth, you're going to the
I'm going to
fourth?
skip to the fourth.
Okay.
In my mind, it's simple. The proposed ordinance clearly deals with prominent city-owned buildings of historical importance or architectural significance in the city of Wichita. It's dealing with city-owned buildings, and that, under analogous circumstances, has been held to be a matter of local concern and not statewide. And the two cases we cite there, which I think are analogous, is the Kansas Supreme Court's decision in McAllister versus City of Fairway, where they held that a proposed ordinance effectively restricting the City of Fairway from locating their own city hall within their city boundaries was local in nature and not a matter of statewide concern. And then also the City of Topeka versus Inman case, where the Kansas Court of Appeals held that the city's acquisition of a private racetrack was not a matter of statewide concern, but instead also local. Turning to the third guideline and the issue of whether or not the city has the sole expertise or a superior expertise as to the citizens to determine whether or not historically significant structures, like Century 2 should be demolished. I understand and recognize the court's rulings yesterday relative to the Charter Ordinance number 221 issue and those types of things which we cite in our brief. So I'm not intending to argue those types of things that I understood the court's rulings to say either were or were not necessarily germane to its decision. But I would like to focus on this. As the petition challenger in this case, it is the city's burden to establish that this proposed ordinance is void. And although they claim that the city has the sole expertise to make these types of determinations, I believe the record will reflect that the sole witness they brought in support of that argument, Mr. Ben Nelson, acknowledged during defendant's examination yesterday he has no more expertise than the voters who signed this petition to determine whether or not a historical structure like Century 2 should be demolished. So respectfully, the city hasn't satisfied their burden there. They've talked a lot about public buildings. The court obviously witnessed the examination. We're not talking about 500 buildings here. The Exhibit 11 references 14 at best, and if I understood the city's council across yesterday, she was trying to establish that some of those on that list are not city-owned buildings. So we're dealing with something smaller than 14. The second thing I will note. Currently, yes.
But this ordinance that's proposed isn't limited to current.
It is not. I'm concerned I'll lose my train of thought,
Okay,
but I will do it because I view this as a prism of the vagueness and the breadth argument. But the second thing I want to know is the city called Mr. Nelson. They didn't call anybody from the Historic Preservation Board. This is a bench trial, but I don't think it's inappropriate to comment on who the city called and who they didn't. We didn't hear anybody from the Historic Preservation Board. They didn't bring anybody in here to tell you that the defendant's proposed ordinance is so vague and ambiguous that they have no idea how to apply it. I'm going to get to it in the vagueness argument.
But you actually brought in to me the Historic Preservation Board code section that says how the Historic Preservation Board is selected.
True. I think they're an expert. I think they absolutely are.
Okay.
That's why I think it's very tough to take the city's argument at face value when they say they have no idea how to these terms mean. And I'll get to that under the Guardian title case, the Kansas Supreme Court case in the vagueness argument. And it may be proper that I go there Your Honor, because I feel like I'm starting to
Okay.
blend over. The city contends that this proposed ordinance is first vague for the first reason, because it does not define prominent city-owned buildings of historical importance or architectural significance. If I understand it correctly, the historic importance or architectural significance is the substance of their criticism.
It's one of about five words or phrases that were indicated to be vague.
Okay, and I will do my best to deal with this. But so the basic, as I understand the city's basic contention is that those terms have to be defined, or otherwise this proposed ordinance is unconstitutionally vague. I would respectfully submit, Your Honor, that the term prominent, I looked it up in Webster's dictionary, it says widely or popularly known, so I don't think we're certainly not talking about every city-owned building, and I think that was made clear by Mr. Nelson's testimony yesterday.
And on that one, I would comment that as to one of the buildings, at least, probably both of them because of their underground connection, it is prominent. Century 2 building is located on prime riverbank property, in my estimation, right a block west of the center of the city, which is at Main and Main and Douglas, I believe. And that piece of property actually, I think, has historic significance from time that I would know about, that I would think would be something considered to be historic significance in terms of the 1880s stories about Wichita as a cow town where the trails ran through to herd cattle from Texas to the trains, about kind of a separation of parts of the development here between the city of Wichita and Delano across the street or across the river without a bridge, I believe. But it's not really up to me to determine whether that's prominent or not. I doubt that there would be really a strong debate on whether that building is prominent. The question on prominence, though, goes to potentially other buildings in the future, because this petition deals with any other building.
It does, Your Honor, but it also has an additional qualifier, if you will, in the historical importance or architectural significance criteria. And so, without belaboring it, we addressed the Kansas Supreme Court's decision in Guardian Title Company versus Bell, I think, starting at page 18 through roughly 21 of our opposition memorandum. I think at least a brief discussion of the facts of that case, I think is appropriate. What was basically at issue in that?
I've read it, but I've kind of forgotten it, so I'm glad if you can give me a review.
I'll do my best to be concise. What was at issue in that case was the legislature had enacted a piece of legislation that was designed to prohibit or define unfair trade practices in the insurance industry. And it used the term, I believe it was controlled business. And it was challenged, and the district court held that the statute was unconstitutionally vague because there was no defined term for controlled business. And the district court examined the similar statutes of other states and noted that there were typically, perhaps all, I'm not sure, it wasn't clear from the case decision, but the states had defined controlled business in their similar statutes and an expansive language. And the Kansas Supreme Court ultimately said that the fact that the controlled business term was not defined did not render it unconstitutionally valid or vague. It first noted that a court has an obligation to construe proposed ordinance or statute. I would argue proposed ordinance by analogy as being constitutionally valid against vagueness and overbreadth challenges if there was any reasonable way to do it. So the court obviously stated that holding, and also then said the lack of a defined controlled business term was not fatal. It also said that terms and standards can be implied from the substantive content of the statute or ordinance. And I think the thing that I consider the most noteworthy for this particular case is it stated the general test for when a statute or proposed ordinance is unconstitutionally vague. And it then said, which is whether or not the average citizen can understand and apply it under its terms. But it said, when the proposed ordinance or statute is effectively directed to an expert with specialized knowledge of its terms, that's a different matter. And in that case, the court said, well, this isn't, Kansas Supreme Court said, this isn't directed to an average citizen. This is directed to the Kansas Insurance Commissioner, who is an expert and has specialized knowledge of these terms and has consultants at its disposal. And we would argue by analogy, Your Honor.
Well, actually, that case said not just simply that it was directed to the Kansas Commissioner of Insurance, Mr. Bell, but it was directed to the insurance industry. And what that statute was seeking to do was to limit, encourage competition in larger cities where insurance businesses and discourage a lack of competition. In other words, a one insurance company could have a little office somewhere else that's not in their name, but it's owned by them, and they pull business from somebody else in a smaller place to get money for that. Essentially something along that line. That's what the idea of the larger one being controlling of the other one extracting income from those other smaller businesses, I believe. And what they said was not just that the Commissioner of Insurance, as I read the case, understood that term. Those businesses, the insurance businesses, knew what it was talking about. So it really, even though it was, for vagueness, you looked at the average citizen, well, the average citizen wasn't going to be dealing with that term. It was just the insurance commissioner and insurance businesses, and they wouldn't have any confusion about it. Here, we aren't directed to anything like that. Yes, it does say historically important and architecturally significant, but the determiner here is the voter because of the binding election. And I thought, I wanted to make a comment because you made an argument about the average person. We know that they can make decisions and interpret things like this because we have juries. And they make decisions on, and they're just average citizens brought in the courtroom, seated in a jury box, and they make a decision interpreting things that are said between parties, documents that are written between parties, etc. But I see there's a striking difference here between a jury and all the citizens in the city of Wichita. If you took a building somewhere in the city of Wichita and brought 100 people, walked them by it, and asked them, is that historically important? I don't think they'd have a clue. History isn't one of those enjoyed subjects by most students in high school. If you then also ask them, is that architecturally significant? Some of them would have an idea. Some people would have a opinion about that, but I think you'd find greatly vast differences of opinion as to whether a building was architecturally significant or historically important. What happens with a jury, I found to have great confidence in from the experience of having a jury in the courtroom. We bring in a jury and we educate them, or I shouldn't say we, the attorneys and the witnesses educate them about the specific thing that they're going to decide. And they then become not just your average citizen, but 12 people who have an education that is specific to making the decision for that case. And they do an amazingly good job. And I could give you examples of that. But I hope you see the point I'm making. There's a difference between a jury and just opening it up to the public. And there would be something that I'm sure Save Century 2 would put forward if there was they probably advertise. I know they put up yard signs that say Save Century 2, and there would be something to try to ask or tell the public something about why Century 2 is significant or architecturally significant, historically important. But my experience with those kind of campaigns are not much different than the campaign we just saw in our state for who would be on the ballot for Senate, which was basically, that guy's bad. And the other one saying, that guy's bad too. And it really gave us no education on the issue that we needed to know, which was, what does the very little education, I should say. What does that guy support in terms of legislation? And I just don't see the electorate being much better educated, certainly not to the caliber of the people who've sat in my jury box throughout a trial.
And I understand the point that you're making, Your Honor, and I think that's why I think it's important to consider that the defendant's proposed ordinance does not tell the city of Wichita how to make the determination of whether or not something is historically important or architecturally.
But this gives to the voters of the city of Wichita the decision of whether it's historically important or architecturally significant, such that it should not be demolished.
Well, I would respectfully disagree, because I think you have to consider that the specific governing body in this case has an entity dedicated to advising them as to what constitutes a historic resource under those criteria. So
But there's one conflict with that. That's huge here. You're saying the city can make that determination whether it's historically important or architecturally significant. But there's only a vote that goes to the citizens of Wichita if the city says, let's demolish that building. Then there's a vote. So they would, now the city's saying to the voters, this building is not historically important or architecturally significant to this condition that we need to preserve it, because we're going to demolish it. How can they be an expert for this? The voters rely on that these are architecturally significant or historically important buildings if they're, what they tell the voters is, we're going to demolish it.
Well, I would certainly agree that they've got a duty to observe it, but I think under our ordinance, they have a duty to put it to a vote if their historic preservation board has determined that it is a historically important or architecturally significant building. And I know Your Honor heard testimony on that yesterday and has the code provision, and I don't intend to unduly belabor it, but I would like to emphasize just a couple of provisions, again, if I could, Your Honor. And I believe this is, if I have it correct, what the city has provided as to the code provisions related to the board is now defendants until the end of
I thought it was 10.
10, I'm sorry. And I'm under section 2.121015, which I think is set first at the first page of exhibit 10. And it obviously establishes the Wichita Historic Preservation Board and says the scope of the duties of the board are to advise the city council on city-owned historic resources and to safeguard the architectural and cultural heritage of the city through the preservation of historic resources. And it goes on to say the board may carry out these duties through the identification, documentation, and designation of the city's historic resources. Subsection B talks about the requisite criteria for the members of this board, that they shall all have special interest, knowledge, or training in fields closely related to historic preservation, and at least 3 of them have to be preservation-related professionals. We get over to section 2.121016 under the definition of historic resources defined as including a building with historical, cultural, aesthetic, architectural, and/or architectural significance or other character-defining features with potential importance or value. And I am not
Where is that?
That's the difficulty with this, Your Honor, is section 2.12106, which will be on the first page of exhibit 10. It's got a number of definitions.
Okay, yeah. Which one were you reading?
It'll be on page 3 of exhibit 10.
Yes.
Historic resource in the middle of the page.
Okay.
So the point here, Your Honor, is I think the city's code makes it pretty clear that which type historic preservation board makes these types of determinations routinely. I also forgot to mention that in the guardian title case, I'm not sure I can tell you that the court held it explicitly, but when they were talking about varying definitions in the other states' unfair trade practices statutes, the court said, yes, they're varying definitions, but there's a common theme. I would respectfully suggest that if the language defining a historic resource is not identical to what is in the defendant's proposed ordinance, it minimally is a common theme. And then the second of the city's arguments, as I understand it, under their vagueness and overbreadth, is really the overbreadth. That is, if I understand it correctly, because the defendant's proposed ordinance applies to those buildings having historical significance or architectural importance that are not listed on the historic registry, is therefore overbroad. I'm not going to go back over the testimony and the only list that's been submitted as to what city-owned buildings are on the historic registry. But what I would like to point out is section 2.1020A of the city's code applicable to their historic preservation board, and I think that is on page 7 of what is Your Honor's exhibit 10.
The functions.
Yes, and so the city's code states the board will have the following functions. And under subsection A, it says the board shall survey and inventory the historic resources within the city. To me, that clearly says there should be a list. I mean, the Wichita Historic Preservation Board surveys and inventories the historic resources within the city. It then goes on to say, and those which may be eligible for listing on the Wichita Register of Historic Places. So to me, Your Honor, and this is just my interpretation, what this code provision says, there may be buildings that have historical importance or architectural significance that are not currently listed on the historical registry. In the same way that Century 2 wasn't a month ago, but it is today. And so the point is, Your Honor, this is not overbroad simply because it's not limited to those buildings on the historical registry, because those buildings didn't start out there. They had to undergo the process of the Wichita Historical Preservation Board, identifying them, surveying them, nominating them, and then get designated. So respectfully, the defendant's position is, Your Honor, this is not overbroad simply because defendant's proposed ordinance applies to those types of buildings that are not currently on the historic registry. Given the defined duties and functions of the city's Wichita Historic Preservation.
It seems to me that maybe that would be accurate with what the petition seeks to do for future elections, but not for this one. This election is simply, shall this ordinance be there?
I'm not sure I'm following you.
Okay.
Your Honor.
Well, there's nothing here that sets out or defines that these terms historically important or architecturally significant. It's not, I think the argument would be that at this point, there's not a vagueness argument. There is a vagueness because it's not referenced. It doesn't give a reference to this. But if it were passed and the city had this ordinance, you're saying they would likely look to their own historic preservation board who would tell them what is historically significant and architectural.
Exactly.
That would apply for the future elections, but not for this one, if they do that.
No, but as a practical matter, Your Honor, essentially, too, I don't think there's any issue at this point with which Historic Preservation Board has identified this matter.
But this ordinance, if it is passed by the city of Wichita, does not save Century 2 or the former public library.
To the extent you're saying it's not a preordained result, what would happen, I understand that, and I agree. But it would allow the citizens to actually have a real input on what happens in Century 2, uninvited.
And that then poses the other problem, Ms. Degraff identified, that we not do an advisory election, it's a binding election. And what authority does the city have to call a binding election for that purpose?
I understand the argument, and I guess what I didn't understand was to the extent that Mr. Graff contended we contend our petition is valid. I understand the city's position, but they don't have the authority to do it, but we can do it. Last thing, and I will be very quick. City's council has suggested to you that the proposed ordinance is also vague because as it uses the term adversely affected. I would suggest to you that standing alone, those are not vague terms, but particularly when you consider that the body that they have at their disposal is termed the Historic Preservation Board. And then under section 2.1201, 2.121015A, the scope of their duties are to advise the city council on city-owned historic resources and to safeguard the architectural and cultural heritage of the city through preservation of historic resources. I don't know if not adversely affecting is a subset of preservation of historic resources, but I would respectfully submit it's certainly consistent. So if there's an issue as to whether or not something is going to be adversely affected as to the way, as the city contends, once again, defendants would respectfully suggest they can run that past the Wichita Historic Preservation Board because they're already charged with the obligation to preserve historic resources. And then lastly, Your Honor, and I'm sorry, I'm backtracking. This is back on my last point. We are back to the third administrative guideline on expertise. We addressed this in the brief, Your Honor, and I'll be real brief. And the city has taken the position that the Supreme Court's decision in McAllister, basically, as I understand it, is animated by the special expertise rationale. And I will acknowledge that the court does discuss that, but I would submit the real basis of the Supreme Court's holding in that case, because this is the one where the court found that it was legislative under the first guideline, they found it was legislative under the third, or I'm sorry, under the second guideline, and they found it was legislative under the fourth guideline. But they found it was administrative under the third, and they found that significant with the ordinance in that case for them to be administrative. But the reason why
thank you. You've answered the question I asked Ms. Dickraft earlier.
Yeah, but the reason why they did that, and I'm going to read the quotes and then move on, is because the proposed ordinance was so restricted that it effectively dictated to the city where they could place their city hall. Not only did it dictate where they could place the city hall, it told the city, you can't put your city hall in your city. And I would like to read just real quickly the quote that I think support that. This is on page, the site for this case is 289 can 391. And I think it starts at page 408. And the court says, we agree that the city hall petition, which is one of the petitions that issued in that case, is administrative under this guideline because of the sweeping geographic scope of the proposed prohibitions. I'm sorry. They go on to say, in this case, the proposed ordinance effectively eliminates more than 90% of the area within the city's boundaries as acceptable sites. Of the remaining 10%, the record reflects the city would have few practical options from which to choose. Such an extensive restriction has the practical effect of directing the city's choice and belies the appellant's argument that their proposed ordinance is simply eliminating a few possible sites from the city's consideration. And briefly, Your Honor, I would submit that McAllister actually supposed that this proposed ordinance is legislative, because the defendant's proposed ordinance in this case doesn't have those types of, it doesn't dictate to the city. They already have a board, the Wichita Historic Preservation Boards, that makes this type of determination as to what city or historical or architecture as a matter.
Thank you, Counsel. I want to state for the record that, and I don't think anybody in this room doesn't understand this. This is a decision given to the court to make to interpret this ordinance. And examine it on the basis of a number of statutory factors and conditions and case law rulings to see if it is valid to go to the voters or not valid to go to the voters. Though it deals with historic importance and architectural significance, it cannot be determined by what I think is historically important or architecturally significant. That's not the question the court's faced with. The court's just faced with, is this a valid ordinance? I want to say you've briefed this well. You've given good references to cases, statutes, and after 4 days of examining this stuff in depth, I think I have some understanding and direction on where to go because of what you've presented. I would compliment you on two things. One, that you provided as much as you did in 20 days, and both of you. And two, that you did it considering all the things we talked about here in the courtroom and issues and positions much more briefly than it could have been done. And so both of those things are really good things to help a court. And you have given me an education on law that I've not dealt with before, some of which I now have a better understanding for application, not only to this case, but potentially to others in the future. Now, thank you for that. I am intending to issue a written decision on this case, and I am hoping to do it as quickly as possible. I don't expect it to be done today since it's now 5 afternoon. And as I told you the other day, I find my brain starting to lose its concentration capacity about 8 o'clock in the evening, if not before, and be wearied sometimes by proceedings like this, which just call for a lot of attention, a lot of examination, and a lot of thinking and rethinking. So thank you very much. I hope you've had a nice visit to Wichita, Mr. Christopher Snow.
Wow.
And my regards to the people involved in this case and the presentation and the part that they had to. Thank you. We will be adjourned.